challenges to eliminate jurors based on the color of their skin. He appealed his conviction all the way up to the U.S. Supreme Court, and the U.S. Supreme Court decided that our Constitution prevents the exclusion of a juror when it's based on being a member of a protected class, that is, their race or their gender. In other words, now, based on Batson and the cases that have followed Batson, you can't just freely eliminate a juror through a peremptory challenge if that exclusion is based on race or gender or a member of a protected class. In other words, while you may be able to exclude jurors without giving a reason for doing so, if it appears to the court that you are doing so solely on the basis of race or gender or other protected class, then you would be forbidden to exclude them as a juror. So now we have some limitations on the issue of utilizing your peremptory challenges. Before Batson, you could exclude whoever you wanted to, so long as you didn't go more than what was permitted in terms of the number of peremptory challenges. Now, it is important to appreciate that a juror will not be excluded when the court deems it to be one that is done on the basis of a protected class, race or gender. The practice is that the one who's claiming that the other side is excluding somebody based on a protected class, that they first establish a pattern of inappropriate exclusion. That is, it looks like the prosecutor has eliminated the last 4 jurors, and they all happen to be African American, and that appears to be a pattern of excluding based solely on race. Then the process is such that the prosecutor then has an opportunity to show a race-neutral reason for why they're excluding them. If they do that, that is, if the government, in my little example, can explain that I have a race-neutral reason to exclude them, then the juror may be excluded. So the process is, in my example, the defendant would have to show the prosecutor has engaged in a pattern of exclusion based on race. If the court finds that to be a pattern established, then the court would say, what is your race-neutral reason or reasons for wanting to exclude them? And if there are legitimate reasons that don't rise to the level of a challenge for cause, but are legitimate reasons, then the juror may be excluded. And if there are not legitimate reasons, then even though the government wants to eliminate somebody, they wouldn't be able to eliminate them if it's based on a protected class. So that's how the process works when you bring down from a jury veneer to a petit jury and having 12 jurors decide the case when it's a felony. And that's why we bring in so many jurors and where they come from in order to decide the case. Certainly one can waive the right to have a jury trial as well, like the other constitutional provisions. If an accused would rather have a judge hear the case, then that's certainly permissible as well. You can waive your right to have a jury trial and have a judge hear the case. When a jury actually takes place, to break it down as neatly as possible, the judge becomes the judge of the law. That is, all questions of law funnel through the judge. The admissibility of evidence, things of that nature, that goes through the judge. The jury becomes the judges of the facts. So they decide, based on the evidence that's been presented, what is a fact. And the jury's decision at the end is to take the facts that they determine them to be, as a group, whether it's 6 or 12, apply the law that the court gives them, and in that way, putting the two of them together and deciding whether or not the government has established beyond a reasonable doubt whether or not the accused has committed the crime or crimes. The simplest way to show it is they're the judges of the facts. The court is the judge of the law, explains the law to the jury, and that way the jury applies the facts to the law and decide the case. So it brings me to the question of, well, what if you're a juror and you don't like the law? Maybe you're somebody who believes that someone should be able to go ahead and use heroin if they want to. If they're not harming anybody, you don't believe the drug crimes should be crimes. You're a juror on a case, and the guy's charged with possession of heroin. The evidence clearly shows that he possessed a substance, which is heroin, but you don't believe that it should be illegal to possess heroin. Can you find the person not guilty? The answer to that question is that you shouldn't find the person not guilty, because you take an oath as a juror to apply the law that the court gives it to you. That is, again, the judge is the person who is the one to provide the law to you. You have to take the law as the court gives it to you. You apply the facts to the law. So if you're going to render a decision as a juror of not guilty because you don't like the law, you're exhibiting what sometimes is referred to as jury nullification. That is, you're disregarding the law because you don't believe the law, and you're finding somebody not responsible, not guilty, not because of the facts, but because you don't like the law. That's called jury nullification. And in some respects, one might argue that that's illegal, because you take an oath to apply the law, apply the facts to the law as given to you. It's hard to prove that jury nullification occurred. And it's really hard to prove if, in fact, all 12 jurors find somebody not guilty. Generally, there's some kind of issue with respect to the facts where you get a unanimous verdict of not guilty. Maybe one person decided not guilty based on jury nullification, but proving that all 12 of them did is a difficult thing to do. It's because of the concept of jury nullification, that is, the possibility that someone's going to disregard the law, that these non-unanimous states have come out. That is the Apodaca case. The concern is that maybe one or two people are just going to say, I don't like the government, I don't like the law, whatever, I'm going to find the person not guilty because of it. That's why they have less than 12 as a requirement for the decision making. Because of those concerns about having renegade, if you will, jurors, that some states have gone to less than 12 in the decision making process. But in those states that require unanimity, it's important that they all agree. And a party, that is the defense and the prosecution, go over a lot of this stuff in the voir dire process to make sure that the individual is going to follow the law as given to him by the judge and apply the facts that they find them to be to the law, and in that way decide the case. That's a wrap up on the concept of jury trial and jury selection. A good portion of this is in the book. Some of it is not. So I'm going to encourage you to review these notes as we move forward. The next session, which will be distance learning number 6, will focus in on April 1, 2020. That is the disclosure and preservation of evidence, Chapter 9, Section 9.12. And I'll get to that next time. So we'll wrap it up with distance learning number 5.